May it please the Court, my name is Gihansa Samaravikrama and I appear as Senior Counsel on behalf of the Plaintiff X. I appear alongside my learned junior Elise Mitchell. We will both be speaking for 15 minutes each and we reserve 2 minutes for rebuttal.
Thank you. And the defendant's team?
May it please the Court, my name is Declan Sullivan. I appear alongside my learned junior Oliver Colshaw and our instructing solicitor Wade Gittleson for the defendant. Myself and my learned junior will both speak for 15 minutes with 2 minutes of rebuttal.
Thank you. Can we have the submissions of the applicant, Senior Counsel?
Your Honour, this case is about fairness before displacement. It involves a 9-year-old Indigenous child with autism and cerebral palsy, whose home, health, and community are directly at risk through the decision that the defendant has made to demolish this housing complex. We submit that the plaintiff was denied procedural fairness when the defendant resolved to displace her without a genuine opportunity to be heard. I will make 3 submissions to that end. First, that the hearing rule was plainly engaged, given the gravity of the impact on this household. Second, that the rule was breached, as consultation was neither timely, candid, nor formative. And third, that the breach was material. Had fairness been afforded, realistic alternatives were available. Moving on to my first submission, that the hearing rule was engaged. Your Honours, procedural fairness is not optional, where government action strikes at the heart of a person's home, their health, and their community. It is a fundamental principle of justice, and every person deserves the right to be heard and treated equally under the law.
Yes, can I interrupt you? This is in relation to the obligation to give procedural fairness. What do you have to say about the recent decision of Justice Richards in the case of Berea number 4?
Yes, Your Honour. In the written submissions of my learned friends, they have also relied in the Bear case. And we submit that the facts in the present case differ from that in the Bear case in 3 fundamental stages, and that is how we distinguish that judgment.
Did Coroner in fact say that the decision under Section 15 of the housing legislation does not attract an obligation to give procedural fairness?
Your Honour, in that case, there was that judgment if it was found that the rights of the individuals that were impacted were not of an individual nature. If it was only in a group policy nature, then yes, procedural fairness does not come into play. However, we submit in the particular case here, the rights that are being infringed upon are individual to the plaintiff, and therefore procedural fairness does come into play.
Thank you.
My learned friends have erred in identifying that this decision is simply programmatic. As the High Court explained in Kiowa and West, 1985, volume 159 of the Commonwealth Law Reports, page 550, paragraphs 584 to 85, the greater the impact, the greater the content of fairness required. Your Honours, may my junior counsel and I please dispense of formal citations?
Yes.
In relying on the Bear case, my learned friends have relied on its judgment in their written submission. However, there are some stark differences between the current case and that of the Bear case. Firstly, in the Bear case, the plaintiffs were treated as a broader class of plaintiffs. However, in the present circumstances, the plaintiff has unique and profound individual interests. Her apartment has been structurally modified for her wheelchair use, and the relocation risks significant disruption to her disability care. That shifts the decision from a general policy to an individualised impact. Secondly, unlike in Bear, X is Indigenous, a traditional owner of the land, and the tower is embedded within a close-knit Wurundjeri Woiwurrung community. The demolition risks fracturing cultural connections and distancing X from her community. Finally, the age of X also distinguishes this impact. At just 9 years old, displacement from her home will have a more profound impact on her, especially since there is no way to guarantee that she will still be near her community or live in a home that is modified for her disability. The housing complex is far more than just a home. It is her sanctuary, a place that she is supported and able to live independently with her disability. To take away such a home is to upend the foundation of her life. Your Honours, the label programmatic cannot shield decisions that have a direct, profound, and individual impact that affects a child's life.
So, Counsel, this is community housing. It's not a detached single house. Surely there needs to be consideration of other residents in the property. And you mentioned previously about home, health and family. Could it not be said that those things are also matters that need to be determined for the community to determine whether the alternative housing or other developments could promote those ideals, those matters?
Your Honour, we submit that the other residents that live in this complex, a majority of them are also a part of the Wurundjeri Woiwurrung community, and displacement would disproportionately affect all of those residents. And also in the statement by Professor Malatesta, the expert report, on page 2 she highlights that the majority of people that do live in public housing complexes also face a lot of similar disadvantages to that of Plaintiff X. And while this current case is on behalf of Plaintiff X, we submit that the other tenants are most likely going through similar vulnerabilities and would similarly be impacted by this decision.
You mentioned that the majority of the residents are from the Wurundjeri Woiwurrung peoples. Can you point to me in the materials where it says that?
Your Honour, in the facts, it is stated that X lives in this complex with. So in the affidavit of X, Your Honour, paragraph 3, many of her relatives are people that live in the tower and they are a part of the Wurundjeri Woiwurrung community.
That may be the case, but it doesn't specify that the majority of the residents are from.
Yes, Your Honour, I apologise if I misspoke. There is a number of people a part of this community that is living in this complex, and if not part of the Wurundjeri community, as listed on page 2 of Professor Malatesta's report, the majority of people that live in a housing complex just in general, based on statistics, are people from disadvantaged backgrounds that have disabilities, that are from different cultural backgrounds, and would therefore have similar impacts as X.
Importantly, unless correct me if I'm wrong, but the action has been brought forward by the litigation guardian of X only.
Yes, Your Honour.
Is the court at liberty to consider the impact on persons who are not parties to this action, which is the majority or a number of Indigenous population that you're talking about? When we are looking at the obligation to give procedural fairness, which is the topic you are addressing us now, aren't we confined to looking at the impact upon the litigant before the court, not generally other people's interests who are not before this court?
Yes, Your Honour. This action is being brought by X, by her litigation guardian, and the case that we are bringing forward is that our client, the plaintiff X, was denied procedural fairness and that she should have been given consultation. But as an extension of that, Your Honour, all the other people in this that may have been impacted with similar needs should have also been given procedural fairness and the opportunity to be heard in this decision.
Yeah, but this is not the vehicle to argue their cases. Do you accept?
Yes, Your Honour.
Confined to the impact on the litigant before the court, which is X.
Yes, Your Honour. Our case will be based on X specifically. This leads me to our second submission, that the hearing rule was breached. Your Honours, I shall address the breach in 3 parts. Firstly, timing and candour. Consultation began only after the defendant had already made up their mind. By September 2023, the decision to retire the towers was internally settled. and by October 2023, demolition had been announced as the default solution. Within a single month of the defendant had both decided and declared its course of action. That is not consultation. Our learned friends assert that the decision is preliminary and that it has no immediate effect on the plaintiff's rights. However, the announcement of retirement sealed the fate of this plaintiff's home. To say that her rights were untouched until actual physical displacement had occurred is just Homes Victoria attempting to escape their fairness obligations by downplaying the finality of this announcement. As emphasised in Moseley and London Borough of Haringey, fairness demands genuine consultation while proposals are still at a formative stage, with reasons and alternatives disclosed so that those affected can respond meaningfully. This principle has been echoed in Australian cases such as the Brisbane City Council and Leahy, as well as PJB and Melbourne Health. Secondly, the formative stage requirement. The consultation that did occur was confined to relocation logistics, while the central question, whether demolition was even necessary, was never open for discussion. Fairness demanded that options remained genuinely open. Homes Victoria had to be willing to depart from a demolition decision if feasible alternatives were shown. It was clear that this willingness did not exist. The defendant had made up their decision and they expected the plaintiff to follow blindly. The expert report from Professor Malatesta underscores the profound human consequences of relocation. Based on past relocation programs, she advised that residents often face wide geographical dispersal due to the scarce and scattered public housing that is currently available. She explains that such a move is likely to fragment cultural connections and dissolve the informal support networks that residents rely on every day. For the plaintiff, who is already a highly vulnerable 9-year-old, these are not theoretical concerns. Relocation would strip away the familiar structures that sustain her well-being, leaving her exposed to upheaval, stress, and the loss of critical social and cultural connections. The impact on her is profound, tangible, and preventable if alternative options had been considered. Thirdly, reasonable adjustments and the duty to inquire. This plaintiff lives with both autism and cerebral palsy. As this very court emphasised in the Matsu Katadao and Yarra City Council case, substantive equality means that processes need to be genuinely accessible, not just formally available. Furthermore, the case of Castles and Secretary highlights that when the state has control over the conditions of a vulnerable person's life, it carries a profound and active responsibility to protect their rights.
And counsel, just in that same vein, don't we need to consider the impact if we don't allow the demolition to go ahead? I mean, we also have to consider the fact, or the affidavit by Alexander Garg, who's the Chief Executive Officer, who says, over the past 2 decades, significant works have been undertaken to maintain lifts, boilers, fire systems. Despite this, the towers are now reaching the end of their useful lives. I mean, they've tried everything and it hasn't been successful. So I'm concerned about the residents and their safety.
Your Honour, based on the report by Professor Guan, who is an expert in public housing complexes and is an architectural engineer, she has highlighted that it is incorrect to say that these towers are at the end of their life and that a lot of the safety concerns that Mr. Garg has addressed can be resolved or amended using other alternatives other than demolition. That being said, the safety concerns that he is alleging are not current and they're not imminent danger. It's more so that they're not up to standard, and that's why they would like to improve upon this building. And according to Professor Guan's statement, there are ways of improving the building without needing to demolish the building.
In other words, the remedial actions which would assist with the problems had not been considered as a viable option.
Yes, Your Honour. And Professor Guan further states the lack of a feasibility report. Had that report been there would have been options for alternatives rather than redevelopment.
Whilst you are interrupted, there's the state affidavit of X and statement of Professor Guan and the statement of Guard and also the Malatesta report. Which bits of the evidence are you putting before the court?
Your Honour, in our submissions, we will be relying
Which documents do you rely on?
primarily on the evidence from Professor Malatesta and Professor Guan,
Yes.
as they are both experts in the field, and we are also relying on the affidavit of X as well. Before I continue, Your Honours, may I request an additional 2 minutes to conclude my submission?
Yes. You've asked a question.
I will now move on to my third submission. The defendant will submit that these factors are minuscule and not material to the matter, but the law states that materiality is satisfied if the decision could have been different had fairness been afforded, as highlighted in the High Court of NZ-APC. The threshold is not one of certainty, but whether there was a real possibility that a different decision could have been reached had proper process been followed. In the present case, we submit that it could. Had the plaintiff been given a procedural fairness, there was a realistic possibility of alternatives, such as staged retrofit, an in situ or proximate lodging, or at the very least, an enforceable right of return. These were rights-abiding alternatives, and they were consistent with the family's expressed concerns, as listed in the Affidavit of X, paragraph 15 to 18. This concern is also reinforced by the expert evidence of Professor Guan, a leading authority in large-scale remediation and the retrofitting of high-density housing. In paragraph 10 of her statement, she outlines the many viable options that the defendant could have pursued to retrofit the towers effectively. She also highlighted the lack of the feasibility report.
And you can take it that we read the report really closely, so you need not tell us that.
Yes, Your Honour. Without the presence of this report, it appears that the defendants have acted on assumptions rather than evidence. A striking example of decision-making divorced from care or scrutiny. The defendant not only failed to consult with the plaintiff, but also seemingly failed to consult with any experts in reaching their decision. Our learned friends cannot assert that the final outcome would have been unaffected by consultation when there appears to be no expert evidence to support their original decision. When justification is absent, unlawfulness follows. Unfortunately, Your Honours, the defendants did not take the necessary steps to protect the plaintiff's rights. A vulnerable 9-year-old child was left to face the consequences of a careless decision made by a government corporation. This is not simple administrative oversight. It is a failure to protect this child's rights and well-being. Your Honours, the plaintiff does not ask for special treatment. She asks for fair treatment. Fairness would have meant timely disclosure, genuine consultation, adjustments for disability, and real consideration of alternatives. Those are not luxuries. They are legal entitlements.
Can I just ask you another question? This is about the material that is before the court. How are you using that material? Are you saying that it should address the issue of materiality before the court?
Yes, Your
And
Honour.
are you also saying that if natural justice had been, procedural fairness had been given, that this is what the applicant X would have said? Are you using the reports or the evidence in two ways or one way?
Your Honour, the expert reports that have been given to us are preliminary evidence in regard to the alternatives that could have been used. They're not, however, very comprehensive. And so if there was consultation, there would be more comprehensive consultation. The same with the affidavit of X.
That's not the question I'm asking. The question is, are you saying to the court, have a look at these reports? If we had been given procedural fairness, this is what we would have put before the decision maker?
Yes, Your Honour. That is what we are submitting. But
And
if
you're also saying it goes to the issue of materiality, because the court can look at the material and say that realistically, this may have changed the decision.
yes, Your Honour.
Two uses you make of the material.
Yes, Your Honour. If there had been consultation, this material does show the alternatives that could have been considered instead of demolition. Accordingly, we submit that the decision was unlawful and that the court should grant relief. Grant the relief that is sought and restore a rights-compatible process. This case is not just about the law. It is about a vulnerable little girl who deserves more than just to exist in this system. She deserves to have her voice heard and her rights upheld. If your honours have no further questions, that concludes my submission.
Thank you very much. Yes, we'll hear from the Junior Counsel, Ms. Mitchell. Yes, go ahead.
May it please the court. Your Honours, this case is about whether Homes Victoria acted lawfully when it chose demolition without consultation, without testing alternatives, and without truly viewing the rights displaced. We submit it did not. To that end, I make two submissions. First, that the defendant failed to comply with Section 38, subsection 1 of the Charter of Human Rights and Responsibilities Act 2006. And secondly, that this court should look to international materials to provide persuasive context under Section 32, subsection 2 of the Charter. Your Honours, before I begin, I seek leave to address that second point, as it's not contained within our written memorandum, however, directly responds to our learned friend's written submissions.
Yes.
Thank you, Your Honour. Section 38, subsection 1 makes it unlawful for a public authority in making a decision to fail to give proper consideration to a relevant human right. As held in Castles and Secretary of Justice, this section has two limbs: proper consideration and substantive compatibility. We submit that neither of which were met, and I'll address the failure of each limb in turn. The first limb, Your Honours, is proper consideration. As Justice Emerton held in Castles and Secretary of Justice, proper consideration requires a real, genuine, and disciplined inquiry. That is, that the decision maker must understand which rights are being related, assess the extent and nature of the limitation, and balance competing, private, and public interests. Subsequent authorities, such as MZPAC and Minister for Immigration and Border Protection, have interpreted this to require a genuine evaluation of alternatives. That standard was not met here, as the record provides no evidence of the genuine evaluation of retrofitting as an alternative. Our learned friends at paragraph 5 under ground 2 on page 4 of their written memorandum assert that retrofitting was considered, citing various reasons for Homes Victoria's conclusion to ultimately opt against it. However, Professor Jessica Guan, a structural engineer with over 20 years' experience specifically in retrofitting, claims that it is a viable option and that a comprehensive feasibility study is required before a decision is made as to whether to demolish or to retrofit. She also confirms that no such study has been commissioned or released by Homes Victoria. Despite this, the defendant dismissed retrofitting as being not feasible without having undertaken the very study that experts deem necessary in order to reach that conclusion in a real, genuine, or disciplined way as required in Castles.
Are you saying, Ms. Mitchell, that the rights, if they were to be considered and Section 38 applied, weren't considered at all or not properly considered?
Your Honour, we submit that they were not properly considered and that there was not substantive justification for the limitation on the rights, which I will discuss.
On what basis are you saying that the rights of X were in fact considered at all? Where is the evidence to indicate that that was taken into account at all?
Your Honour, in the statement of Alexander Garg, it states that he simply turned his mind to the considerations and understood the impact that it would have on children, older people, people with disability, and specific cultural communities. However, we submit that this does not form proper consideration, as proper consideration would have involved the genuine evaluation of alternatives as required under NZAP.
And given the peculiar or special circumstances of this applicant, that is individualised circumstances ought to have been considered.
Yes, Your Honour.
Whether they prevailed or not is another matter, but ought to have been considered. Are you putting that to us or you're not?
Yes, Your Honour, I'm putting it to you. Our learned friends cite Bear and Holmes Victoria throughout their written submissions. However, that case is clearly distinguishable, as the court in that case was presented with a detailed evidentiary record of consultation and a feasibility study, which provided evidence which is absent here, rendering the decision inconsistent with the discipline requirement under Castles. Your Honours, we do not contend that Holmes Victoria was legally obligated to choose retrofitting over demolition. Rather, that all viable alternatives should have been genuinely evaluated before the decision was made, no matter which way the cookie ultimately crumbled. Here, evidence of genuine evaluation was absent. Therefore, proper consideration is not satisfied. Your Honours, the second limb is substantive. Of course, Your Honour.
Some of the submissions that you're making appear to have the tenor of making submissions about denial of procedural fairness, and some of it touches on the proper consideration of Section 38. How does the concept of, or the obligation to give procedural fairness interact with Section 38 obligation? Is Section 38 obligation a stand-alone obligation that has to be complied with, irrespective of whether natural justice applies or not?
Yes, Your Honour. Section 38, subsection 1 is irrespective of procedural fairness. However, the arguments coincide in the way that the feasibility study would contribute to both. And therefore, the feasibility study demonstrates that there was no genuine evaluation of the alternative, which is required under Section 38. Further, the consultation was not present, therefore breaching procedural fairness. The second limb is substantive compatibility, which can be assessed under Section 7, subsection 2 of the Charter. This section provides a cumulative proportionality test. If even one element is missing, the limitation cannot stand. It requires the consideration of the nature of the right, the importance of the purpose, the extent of the limitation, the relationship between the limitation and its purpose, and whether there are less restrictive means reasonably available. Our learned friends rely on Thompson and Minogue at paragraphs 96 to 97 to suggest that compatibility with rights need only be to the extent reasonably possible. Your Honours, these paragraphs specifically, in fact, impose a much higher threshold, requiring a greater degree of scrutiny and an evidence-based proportionality analysis under the section, which I will now apply for the court. This decision breaches multiple Charter rights: Aboriginal cultural rights, equality, protection of families and children, and privacy, family and home. These rights cut directly to dignity, stability, and cultural identity, interests at the very core of human rights protection. We accept that the purposes of safety and housing supply are indeed important. However, as held in Cotterell and Romanes, the importance is a factor to be balanced, not as a justification in of itself.
Can you take us through the basis of which you say each of these rights have been contravened?
Yes, Your Honour. The impact is severe. The plaintiff is a disabled Wurundjeri child, and she is being removed from the environment which has been specifically tailored to her individual needs. In her affidavit, she states that without these modifications, it is very difficult for her to live safely or independently. Under Section 17, subsection 2, every child has the right, without discrimination, to protection in their best interests, with PJB and Melbourne Health confirming that these interests are to be a primary consideration.
But isn't the respondent seek to provide accommodation that deals with the condition, to assist in the condition?
Your Honour, there is nothing on the facts to ensure that the plaintiff will be housed in appropriate conditions in the interim between the demolition and reconstruction of the building. Therefore, we submit that her rights have been breached under Section 38, subsection 1. Further,
When you say rights, can you be precise and tie it into the legislation? Which rights?
yes, Your Honour, her rights as a child, in terms of the protection of the child.
Which provision? We have
Se-
to be fairly precise.
Yes, Your Honour. Section 17, subsection 2. Here, her best interests are not being upheld, as demolition disregards her safety, while a less restrictive means remains unevaluated. Further, our learned friends claim that the interference with the home under Section 13, subsection A, was not arbitrary. Yet, PJB holds that interference is arbitrary where it lacks an evidential foundation. The decision was made without the feasibility study that experts identify as essential to evidencing a genuine evaluation of less restrictive alternatives. And accordingly, the removal of the residents from their home without an evidential basis is therefore an arbitrary means of removal.
But they haven't been removed yet, haven't they? Wouldn't you need to wait for the VCAT decision for the eviction notice before they're removed?
Your Honour, as held in PJB and Melbourne Health, once the decision is made, it is assumed to be in operation even before the bulldozers arrive. Therefore, it is considered arbitrary under the assumption that it will continue.
So they have a collective total as a team of 13 minutes, subject to any time extensions that the judges are allowed to give, but time extensions cannot be more than 2 minutes. They've reached the
You've reached the limit?
Yes.
All right, someone's supposed to alert us.
Yes. Sorry, the knock wasn't loud enough.
Yes, are you seeking permission to?
Your Honour, may I extend by another 2 minutes? Thank you, Your Honours. Finally, our learned friends state that demolition is necessary to achieve safety, accessibility and supply. However, as held in PJB, necessity requires proof that no less restrictive alternatives exist. Professor Guam states unequivocally at 18B of her statement that retrofitting offers a less restrictive means reasonably available to achieve the objectives. As to supply, if Homes Victoria's primary objective was to increase public housing supply, then demolition cannot be the answer. Demolishing this complex would displace the 10,000 current residents and force them to seek accommodation within what Malatesta warns is an already strained housing market. This would only worsen the very supply issue that Homes Victoria aims to address. Your Honours, I turn to my second submission, that under Section 32, subsection 2 of the Charter, that this court may look to international materials as persuasive context. Our learned friends submit at paragraph 15 that international instruments are broad and aspirational and do not create freestanding obligations. Your Honours, we accept that they are not directly enforceable, but that is not the point. Section 32, subsection 2 expressly directs this court to consider international law when interpreting charter rights. As confirmed in Momsilovic and the Queen and Crack and Mental Health Review Board, international law functions as an interpretive aid, guiding how rights respecting society gives effect to the Charter. Your Honours, we seek the following orders: a final stay restraining demolition, a declaration that the defendant's decision under Section 38, subsection 1 was unlawful, and an order as to cost in the plaintiff's favour. Unless I can assist further, those are my submissions.
Thank you
May
very
it please
much
the
for
court.
your submissions. The defendant's senior counsel. That's Mr. Sullivan.
Yes, that's right, Your Honour.
Yes.
Your Honours, the case before you today is as follows. In September 2023, Homes Victoria made the decision to redevelop the North Melbourne public housing towers. The decision...
You're familiar with the facts. I just want to hear you on the law, the arguments that have been made.
The two key issues for the court to decide today, Your Honour, are the issue of procedural fairness and human rights. I will address the issue of procedural fairness and whether there was an obligation for Homes Victoria to hear from the plaintiff's family and or her community before making the redevelopment decision. And my learned junior will address the issue of human rights and whether the redevelopment decision unjustifiably infringed upon the plaintiff's rights under the Victorian Charter. Your Honours, in addressing the issue of procedural fairness, I'll do this through three separate points. The first 2 points both relate to the same question, which is under what avenue has an obligation to hear from the plaintiff's family and or community actually arisen under? Point 1, we'll look at whether there has been a common law avenue under which an obligation to hear has arisen under, to which we submit there is not. And point 2 will be whether there is a statutory obligation having regard to section 38 subsection 1 of the Victorian Charter, which also mandates an obligation to hear from the plaintiff's family and or her community. And to that we also submit there is not a statutory obligation. However, if your honours are unconvinced by our submissions on either of those 2 points, my third point will be that even if there was an obligation to hear from the plaintiff's family and or her community, this obligation, if it were carried out, would not realistically change the outcome of the redevelopment decision. Your Honours, turning to the first point, which is whether under the common law there is an obligation to hear from the plaintiff's family and or her community. The relevant principles, Your Honours, can be found in the case of disorganised developments reported in 2023 in volume 410 of the Australian Law Reports at page 508. And Your Honours, may I dispense with formal citations on behalf of myself and my learned junior?
Yes, permission granted. Before we get onto that, Mr. Sullivan, isn't the rule of statutory construction in relation to procedural fairness, this is what the High Court has said, that unless and until the obligation to give procedural fairness is expressly abrogated by a statute, then any decisions that affects rights, interests, not just rights, interests of any person, procedural fairness ought to be given.
That's correct, Your Honour.
That's the starting point when you look at a statute to see whether there's express abrogation, or I think the other expression courts have used is necessary entailment. On any view of the matter, procedural fairness has been excluded. So that's the starting point, isn't it? Where we look at the statute to see whether that's negated or not, and you have to deal with the judgment of Justice Richards to see whether that assists you, doesn't. What do you make of it? That's the first question, isn't it?
That's right. And there is no statutory abrogation of any obligation to hear in this case. So the principle then turns to not just are rights affected, but if I can take Your Honours to paragraph 33 of the judgment in disorganised developments, Chief Justice Kiefel and Justices Gagler, Gleeson and Jago state that rights must be directly affected. And so we're not just assessing are rights or interests affected, which is the first step. We also need to assess, are they directly affected? And so because there is no statutory obligation, the first point of whether the common law principle of whether an obligation to hear has arisen is whether any rights have actually been affected. And to that point, we submit that no rights have been affected. And the reason for that is because the decision itself is best characterised, we submit, as a signalling of Homes Victoria's future intention to develop. Our learned friends in their oral submissions submitted that the development decision is definitely going to go ahead. It is a done deal and it will occur. However, the development decision is not a done deal. It does not ensure that redevelopment will actually occur. At any point in time, the Minister could change policy and redevelopment may not go ahead. But Your Honours, the key question here is, has the redevelopment decision actually altered the status quo pertaining to the plaintiff's legal rights? And the answer we submit is no. The redevelopment decision does not evict the plaintiff from her home. In fact, it does not move Homes Victoria closer to evicting the plaintiff from her home. Under the Residential Tenancies Act, Section 322, if Homes Victoria were to seek to evict the plaintiff from her home, they would need to acquire a possession order to do so. The prerequisite for seeking a possession order is to have issued a notice to vacate. And under Section 91 ZY subsection 1B of the Residential Tenancies Act, the prerequisites for issuing a notice to vacate is that all the necessary permits and consents must have been obtained.
But Mr. Sullivan, as I understand it, your client, or the respondent, I ought to say, publicly acknowledged that they would retire this property. And furthermore, a month later, the Victorian government announced its intention, announced the intention to demolish. So isn't this all referring to what is eventually an inevitability?
Your Honours, we submit that it isn't an inevitability because policy changes are a realistic possibility that could occur in the future. But the steps taken to implement this redevelopment decision, they could affect rights. And so if the redevelopment were to go ahead, we do submit that it would affect the plaintiff's rights. We do affect that this impact would be significant, and we don't seek to downplay the impact that redevelopment itself would have on the plaintiff.
So are you saying that until such time as the respondent serves a notice to vacate, that there are no rights affected?
Yes, that's our submission, Your Honours. But even if you're unconvinced by our submission,
But there are two ways to have a tenant or provide a resident removed, either voluntarily or forcibly. Isn't a notice to vacate a mechanism where a resident who does not wish to leave is given a notice to vacate?
sorry, Your Honour, could you rephrase the
So
question?
my point is, a notice to vacate is served on a resident who does not wish to vacate, who does not wish to comply with the directive of the landlord or the residential rental provider to leave. So how do you say that the right is only affected or compromised or harmed in any way upon a notice to vacate, as opposed to an announcement or a directive from the respondent saying, well, you need to leave?
We submit that a notice to vacate would have an effect on the plaintiff's rights because it would put into motion the processes that would enable a possession order to be sought. However, we submit that because the prerequisites for issuing a notice to vacate, namely obtaining the permits and consents, have not actually occurred, that we aren't actually at the stage where a notice to vacate could be issued and actually affect any of the plaintiff's rights. Yes. So we have the decision, which we characterise as a signalling of future intention to do something, in this case to redevelop, and then the steps taken to give effect to that intention could actually affect rights. For example, obtaining permits and consents. However, Your Honours...
Decisions are made along the way before residents are evicted. So if the decision-making process has to follow a statutory path where certain steps have to be complied with. Now, why do you say that somebody has to sit and wait for the bulldozer to come, which is the final? You're not even saying the final decision, you are actually saying the implementation of the decision means your rights are affected. Why can't you attack a decision at one of the statutory steps through which the matter has to travel compulsorily before you get to the retirement of the particular property in question? It's not correct to say, is it, that you have to wait for the final decision all the time, because the case law says you have to study every step to see whether that step has a legal air of finality about it. That step itself, whether you arrived at the final stage of the bulldozer arriving with the eviction, is a separate matter. But you seem to be putting it in a black and white way to say unless the notice is given and you want to vacate the premises, you don't. Your decision, sorry, your rights are not affected. That doesn't sound right.
Well, Your Honours, even if you are unconvinced by our submissions, then under the common law, the question then turns to, are rights or interests directly affected? And the outcome is no different because the rights or interests in this case are not directly affected. The statutory power to redevelop is exercised under Section 15, subsection 1A of the Housing Act. And that power is directed at development of land, not at an individual. And this is in stark contrast to a decision, for example, to evict a tenant, which would go directly to that individual's rights.
Are you saying individuals are not going to be affected by this decision? It's all about the people, isn't it?
Yes, Your Honours. So our submission is not that individuals will not be affected. Our first part was that the decision itself would not affect the individuals. The redevelopment will affect individuals. However, that impact is not direct. And that is the determinative point under the common law, is not just is there an impact, but is that impact direct?
So why do you say it's not direct, just to clarify?
Because the power has been exercised to develop land, and individuals are only affected insofar as they are connected to that specific land being redeveloped. In the case...
You're talking about power, you're talking about jurisdiction, ability to do something. But we're talking about affecting of someone's rights. So how is that not affected? How is not the applicant's right not affected? In the way that she puts it.
We submit that the rights are affected by redevelopment, but we rely on that effect not being direct. And because the plaintiff is affected indiscriminately, the decision wasn't targeted at the plaintiff. The decision was targeted at the development of land. The plaintiff cannot be said, we submit, to have been directly affected. Your Honours, turning to the point now of whether there is a statutory obligation to hear from the plaintiff. Our learned friends have submitted that under Section 38, subsection 1 of the Victorian Charter, there is an obligation to afford procedural fairness to the plaintiff. And we accept that submission. Section 38, subsection 1 does have a limb that requires an obligation of procedural fairness. And that specifically is to give proper consideration to how the plaintiff's rights may be affected by this decision. However, the ultimate question for the court is not whether proper consideration needs to be given, but whether an obligation to hear from the plaintiff was required. So the question then turns to, well, does proper consideration require an obligation to hear from the plaintiff? Could proper consideration be satisfied unless an obligation to hear was carried out? And Your Honours, we turn to the case of Berra in submitting that it is not required for an obligation to hear to be carried out for proper consideration to be given. Our learned friends have submitted that in Berra, a feasibility study was carried out and that evidenced proper consideration. However, I'd like to alert Your Honours to the fact that in Berra, there was no feasibility study carried out and no distinguishing can be made on that point. In Berra, if I can take Your Honours to paragraph 158, the following factors were incredibly influential in deciding that the CEO of Homes Victoria had given proper consideration. The CEO of Homes Victoria had provided a statement, had stated in his words that he had turned his mind to the impact of the decision to redevelop, again, the North Melbourne public housing towers, and the impact that would have on families with children, older people, children with disabilities, and also, and importantly, specific cultural communities. Your Honours, if I can take you to the statement of Alexander Gard at paragraph 8, Mr. Gard has given the exact same consideration. He has considered the impact on renters, including families with children, older people, people with disabilities, and specific cultural communities. Mr. Garg hasn't simply stated that he's given proper consideration. He stated who may be affected, but then he's also stated how the characteristics of certain people, such as people with disabilities or people belonging to specific cultural communities, may be affected to a greater extent. And on that basis, we submit that he has given proper consideration.
Was that a time mark?
Yes.
Yes, so you hit your timeline, you see 2 more minutes?
Yes, please, Your Honours. Thank you. And so, analogising to the case of Berra, where very similar consideration was given, we submit that proper consideration in this case did not require consultation. Our learned friends have relied on the authority of Castle. However, if I can take your honours to paragraphs 185 and 186 of that judgment, it was stated that proper consideration merely requires a general understanding of the impact of a decision, and that the court should not scrutinise consideration given overzealously. Your Honours, a general consideration has been given.
I just want to see what your understanding of the obligation to give procedural fairness is. And I think that case may be making a different point. Now, if X is saying here, I haven't been given procedural fairness, and an obligation to give procedural fairness, let's assume, exists, is it sufficient for the decision maker to say, I have broadly considered all these disabled people and cultural differences? Is it sufficient response for the decision maker to say that? Or is the decision maker obliged to consider the individual circumstances of the litigant before the court?
We submit, Your Honour, that because the decision isn't actually targeted at an individual, it'd be very difficult to state that there would be an obligation to consider an individual's rights and how they may be impacted, because that's simply not what the power has been directed at. But we do submit that a broad and general assessment is capable of satisfying the element of procedural fairness and proper consideration.
Yes, let's assume the obligation to give procedural fairness existed. A public hearing was called or submissions were called for. Persons would be making submissions about their personal plight, grievances and the effect that it has on their lives. So isn't the obligation of the decision maker, once that obligation to give procedural fairness is triggered, is to consider the individual submissions that are being made from the affected persons?
Your Honours,
Is it enough to say, I've looked at all of this as a group here, Indigenous people and disabled people. Look at my affidavit, I've looked at those kinds of people. Is that sufficient?
the consideration to how the plaintiff's rights may be affected goes beyond simply Mr. Garg stating that he's considered it. He's considered specifically how it may affect them, but importantly as well, he is committed to a household level consultation with Indigenous residents to help assist them through the relocation process and mitigate the impact it has on them. And that demonstrates that he understands how intimately they may be affected as a cultural group by this decision.
I don't want to eat away into your 2 minutes, so you go ahead.
It's okay.
You can have half a minute more. Tune up your time.
Right, the final point is that even if there was an obligation to hear, that carrying out that obligation would not realistically result in a different outcome. If consultation took place, what would actually happen? Well, the residents could state how the decision could impact them and their concerns about that decision. But, as I've just presented to you, Mr. Garg has already considered this impact, and therefore reconsidering already considered considerations is unlikely to realistically change the outcome. On top of this, there is also the broader policy consideration of increasing housing supply that makes it unlikely for a different decision to be reached. I now defer to my leading junior. Thank you.
Mr. Culshaw.
May it please the Court, I turn to the issue of human rights, specifically whether the decision to demolish was an unlawful and unjustifiable limitation on the plaintiff's human rights under the Victorian Charter. I'll address this in 3 points. First, identifying the interferences with the particular rights under the Charter. Second, had those rights been interfered with, whether they were justified under Section 7.2 of the Charter. And third, what consideration should be given to international obligations and treaties when considering if rights have been limited under the Charter. In assessing whether rights have been limited under the Charter, the starting point for the Court is to assess which rights have been limited. Our friends in their oral submissions have raised Section 17, which is the right to a family. Per their written submissions, they have also submitted 13A, a right to a home, and Section 19, a right to enjoy cultural and kinship ties, the cultural rights as an Indigenous person, Section 19.2 specifically. as well as Section 24 in their written submissions, which pertains to the right to have a fair trial, which we submit ultimately was not breached in this case, as such a trial is before Your Honours today. Ultimately, however, we do concede that there was likely a breach, particularly of rights under Section 13A, Section 17 and Section 19, the right to home, the right to family and cultural rights. And whilst there may be some interference with such rights, but regardless of how many rights or what rights were interfered with, the crux of the issue of human rights is whether Homes Victoria was justified under Section 7.2 of the Charter. And if I could take Your Honours to this provision, it states that a human right may be subject under law only to such reasonable limits as can be demonstrably justified in a free and democratic society based on human dignity, equality and freedom. And it lays out the particular factors that have to be assessed, as our learned friends have helpfully submitted. The core factor in dispute here is under Section 7.2e. Were there any less restrictive means reasonably available for Homes Victoria to achieve the purpose that the limitation on these rights seeks to achieve? We submit that there was not, and I'll address this issue in 3 points. First, that retrofitting ultimately, or any other alternative means, cannot be a viable option, and redeveloping the land is the only viable option, as that is what Mr. Garg has set out. Second, even had there been alternative means that were available, we submit that they were not less restrictive as alternatives available to Homes Victoria. And third, even if there were less restrictive means reasonably available, they ultimately do not would not be able to achieve the purpose of the limitation on these rights that seeks to achieve, and namely those purposes being to remedy serious life safety structural defects in a mid-century housing tower, now well beyond its design life, and unfit.
Well, how do you address then the statement of Professor Jessica Blunt? She says that, in my opinion, Homes Victoria has multiple technical options to extend the useful life of the towers, and outlines A through to E those options, and that these measures would directly address many of the deficiencies.
We do accept that technical options existed to improve some of these issues inherent to the tower. But the test is not whether these technical interventions can be improved in isolation, but whether for this particular North Melbourne housing tower can, in practice, would that retrofitting present a viable, less restrictive alternative? And we submit that it would not. And that goes to my second point.
Before you do that, Counsel, you mentioned that there would be life-threatening defects. Where's the evidence of Mr. Garg saying that?
Mr. Garg states that the defects per 5 through to 7 of his written submissions, he, or particularly paragraph 4 of his submissions, the defects with the tower include the poor soundproofing between the apartments, the thermal performance, the sustainability issues, the structural performances, such as the large panel construction not meeting contemporary safety standards, as well as safety standards, the fire protection standards. So despite upgrades...
But this is, correct me if I'm wrong, this is not a situation where there's been a building order or a safety order or any of that sort. So my concern is perhaps they preempted this issue by announcing that there needs to be a redevelopment without actually understanding what that involves, and there isn't even a mention of the alternative sites or proposed sites here.
With respect, Your Honour, significant work has been undertaken over the past 2 decades to alleviate these issues that are inherent to these towers, to no avail. And therefore, we submit that that Mr. Garg was appropriately equipped in his assessment that the housing towers were unfit for modern habitation.
Is he an expert? What's his qualification to assess that?
Mr. Garg is the Chief Executive Officer of Homes Victoria. And if I could turn Your Honours to paragraph 52 of the case of bearer, the exact same public authority body, Homes Victoria, and the exact same position within that body, the Chief Executive Officer, was held to be more than sufficient to qualify him to express the opinions in issue. And therefore, Mr. Garg on these facts is experienced to express opinions on the management of ageing housing stock.
What are the concerns of two of my learned friends here? Simply, Mr. Garg is the decision maker. This is guarding the hen house. It's his decision. He makes all these bold statements in his statement. There's no evidence to indicate he's an expert. Even if he was an expert, we wouldn't be paying too much attention to him because it's his decision we are testing. There's nothing to indicate on whom he has relied to make his decisions. You have no experts' reports, and the applicant has put eminently qualified persons' reports before the court. So can you see the problem we've got? Is Mr. Garg is saying all these things and he says, my word is good. Well, is it?
Even if Your Honours are not convinced that retrofitting is not a less restrictive means available, ultimately, if we look to the broader purposes of redevelopment, it aims to expand the housing on the estate in the face of a public housing crisis.
Can we just take it step by step? So we have to look at the decision maker's decision and the material that was before him. The applicant has put in new material, which ordinarily we don't look at in a judicial review. We have to establish why we have to look at the new material, and we asked counsel questions, why are you giving us this new material? And they said it shows materiality and it shows what we would have said if Mr. Garg had given us a chance or natural justice. Now you are putting Mr. Garg, the decision maker's word, through his statement, but we don't have any experts' reports from your side counteracting what the applicant is.
Respectfully, Your Honour, even the lack of expert evidence or independent feasibility report, such evidence would still be largely unnecessary, as even if that evidence were brought before Mr. Garg, the decision wouldn't have been made due to the substantial evidence that he has cited, and if we are to assume that he is reliable by virtue of his position, and there's nothing to suggest that he's acting on bad faith, then he seeking to fix the issues with the building was not ultimately feasible.
Counsel, has the expert, Ms. Guan, mentioned how long it takes to retrofit?
She had not mentioned in her statement, but
So what does Mr. Garg say about retrofitting? How long does that take?
Mr. Garg states, I believe it's per H of his affidavit, that it would be, 7 and 6. It would be the retrofitting would cost at least as much and also take the same amount of time. It would be tenants would be relocated under both redevelopment and retrofitting for several years per Mr. Garg's evidence. So the disruption, either method taken, would not be any materially different. On the effect on the tenants, the outcome is the same, but the broader purposes that it aims to achieve is not the same. And turning to that purpose, that broader purpose, that cannot be understated, Your Honours. Because we are in a profound housing crisis with thousands of families languishing on waiting lists, we must weigh the rights of current tenants with the rights of Victorians without any home at all. And to increase the capacity threefold, add tens of thousands of additional dwellings across the city, and increase the very livability and safety and accessibility for current tenants, we ultimately submit that it was not an unjustifiable limitation on the right in achieving this broader purpose. Other factors to be considered under Section 7.2 also include the importance of the purpose of the limitation under Section 7.2b. In this case, it is justified as it aims to alleviate that broader public housing goal, as well as retrofit and fix the building themselves, redevelop, sorry. And the extent of the limitation should also be considered under section 7.2c. In this case, the limitation is only temporary, and tenants will have the chance to return to the North Melbourne Housing Tower. Household level consultations in the relocation process aim to make it as seamless as possible, and we do not undermine the significance of this right. However, it will be reduced significantly by the ongoing consultation progress, by the fact this is only a temporary interference, and that ensures that the plaintiff's housing situation for the future is markedly improved. And for those reasons, we submit that Homes Victoria was justified under section 7.2 in limiting or interfering with the plaintiff's rights under the Charter. I now turn to international obligations, and we first submit that there had been no violation of any international obligations. And second, had there been a violation of international obligations, this can only inform a violation of a right under the Charter and will have no effect on the outcome of this case, as any interference with Charter rights was demonstrably justified under section 7.2. Our learned friends raised section 32.2 of the Charter of Human Rights, helpfully, but this makes clear that international law may inform the interpretation of Charter rights, but that alone does not create any freestanding courses of action. And the court is not asked to enforce these treaties directly, but rather interpret the Charter rights in their light. And against that framework, the relevant instruments that come into light are the International Covenant on Civil and Political Rights, protecting privacy, family, home and cultural life, as well as the International Covenant on Economic, Social and Cultural Rights, which recognises the right to adequate housing, and the United Nations Declaration on the Rights of Indigenous People, affirming Aboriginal people's cultural rights and their connection to land. Whilst fundamental and important, these are broad and aspirational and do not prescribe that dwellings are to be maintained in perpetuity, nor do they prohibit redevelopment when that redevelopment aims to improve safety, habitability and accessibility. On the facts, we submit that the plan by Homes Victoria to redevelop is not in tension with these rights, but the end goal is to further them by rebuilding and securing adequate housing that does increase safety and accessibility and dignity for current tenants and expand access for many more. That is fully consistent with international obligations to progressively realise housing. If I could turn you on to Article 11 of the International Covenant on Economic, Social and Cultural Rights. Regarding her rights of Indigenous people, the decision does not aim to sever a cultural connection, but to sustain it in safer conditions. No international instrument requires the government is to preserve unsafe, outdated housing stock at the expense of tenant safety or the broader housing need. And to contend that temporarily displacing X with a chance to return to a fully accessible building, pardon me, may I just have 1 minute of additional leave just to finalise my conclusions?
Yes.
Thank you. To contend that temporarily relocating X to a more fully accessible building in which corridors, common areas, all the facilities will now be accessible for X, rather than just her apartment. If I could turn you on to section 6 of X's affidavit, it's only her apartment that's been purposely built. So she would be able to engage with her kin and community to a greater extent and her autonomy be expanded. And that is doing the exact opposite of what my learned friends contend. Accordingly, Your Honours, when we properly understand the decision, it's consistent with international obligations. For the reasons submitted by my leader and that Homes Victoria was under no obligation to hear from the plaintiff's family, and for the reasons I've submitted, that Homes Victoria was justified in its actions, we respectfully ask that the court dismiss the plaintiff's claims.
Thank you. Yes, any reply?
Yes, Your Honour. May it please the court. My learned friends have erred in identifying that the decision has not affected any rights, as it is still preliminary. Your Honours, we submit that considering that there has already been a public announcement by the government and that Homes Victoria has already started to consult with the residents in regarding to relocation, as stated in paragraph 9 of Mr. Garg's statement, that this decision is in fact already impacting their rights. In response to my learned friend's analysis of the Castle's case, we submit that they have incorrectly applied this case. Paragraph 100 and 113 of this case specifically states that when a vulnerable person's life is impacted, there is an active duty by the state to ensure that their rights were considered and safeguarded. Our learned friends have also attempted to submit that the infringement of rights that has occurred is justified. However, considering that experts in the field highlight that alternatives were present, we submit that it was not. And in specific respect to the Bear case, in which they stated that Mr. Garg and Mr. Newport, who was the CEO in that case, are similar, we submit that there was a difference, as Mr. Newport, specifically at paragraph 52, was identified to having a Cert 4 in building and construction, 12 years of experience in public housing, and was therefore qualified to give his opinion. In comparison, Mr. Garg does not have that experience. Finally, in response to the time taken for retrofitting, Professor Guan, at paragraph 18 of her expert statement, expressly states that retrofitting can be staged and targeted so that there is a reduction of disruption on the tenants. That concludes my submissions, Your Honour.
Thank you very much.
There's one slide of it.
Yes.
Thank you, Your Honour.
Try not to ask any questions.
No, go ahead. Our learned friends have submitted that we have erred in classifying the development decision as a preliminary decision that doesn't affect rights. The evidence for this was that the later stages of the development decision affect rights. However, again, that doesn't engage with whether the decision itself affects rights. The evidence is as to later steps taken to implement that decision, which do affect rights. And again, Your Honours, we accept that redevelopment will affect rights, but we also put forward that it does not directly affect any rights. The next point that our learned friends have raised in their reply is that point of Castles, and when vulnerable people are impacted, there needs to be consideration under section 38, subsection 1 of the Victorian Charter. So what are the principles that we can apply to section 38, subsection 1? If I can take Your Honours to paragraphs 87 and 89 of the judgment in Thompson and Minogue. It's been stated that when giving proper consideration, this does not require a sophisticated legal analysis. There is no formula for how proper consideration is to take place, and a broad and general assessment is acceptable. And analogizing to Berra, that broad and general assessment has taken place, and that was concluded in Berra at paragraph 158 of Justice Richard's judgment. Your Honours, the final point is whether Mr. Garg is reliable. If Your Honours accept that Mr. Garg is not reliable as to his evidence on retrofitting, and we accept Professor Guan's evidence, the question then is not whether retrofitting can happen. The question then is whether retrofitting achieves the purposes of redevelopment. Redevelopment has taken place for two reasons. One, to remove the deficiencies in the North Melbourne Public Housing Tower, and two, to increase housing supply for 20,000 people. Retrofitting does not increase housing supply for 20,000 people. For these reasons, we submit and we seek orders that the plaintiff's claims be dismissed. Thank you, Your Honours.
Thank you very much.
Thank you to our presenters for this evening's grand final. So while the judges deliberate the winning team best oralist as well as the runner-up oralist, we would like to invite everyone to head to the Onsign Club for refreshment and drinks while they come to this decision. Please come back. Please be ready to come back potentially around 7:45 p.m. sharp. That's when we intend to get the closing ceremony started. But if the judges require slightly more time, that might change. We'll keep you informed and updated. Please don't leave the area. Otherwise, thank you very much, everyone.
Congrats.
Congrats.
So